Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner. And with me, as always, is my co-host and a senior associate at my law firm, MBK Chapman, Sam Kill. Sam?
Hello, Mike.
How you doing?
Doing well. Glad to be with you.
I'm glad you're here, as always.
Thank you.
Sam, as you know, we're rejoining our guests who hopefully have been waiting an entire week to hear part two of our episode on disabilities, accommodations, and HOAs, and kind of how those work together.
Yeah.
And so when we ended part one last week, for those of you listening or watching, this was a week ago when you heard this, we left off, we described the nature of the tension between HOAs, good HOAs and bad HOAs, and disabled residents that require some sort of accommodation. And then we talked about what the law was,
Right.
and we gave some examples. We talked about the federal law, the FFHA, and then the much more broad California counterpart to that, which is FEHA. And then we promised that when we started part two, that we would start with, okay, now that we've got kind of that out of the way, what constitutes a disability? Who's disabled and who's not? And we covered, again, we mentioned last time that FEHA, being the California version, being more broad, has a more broad definition of who's disabled. So when we talk today, we're going to start the episode at this point.
Yeah.
We're going to do it from the perspective of FEHA, since FEHA is what every California HOA is going to have to abide by anyway.
Correct.
So it covers everything that the FFHA covers and then some. So we're going to look at it from that perspective. What we're not going to do is put up another really cool graphic that shows where the limitations of what constitutes a disability are for federal versus state, because just by the examples we give, you'll probably be able to figure that out. We're going to imply it without saying it outright, just for time's sake. So who's disabled under FEHA, California's law? The people with disabilities, as part of its broadening, California law didn't just limit who's disabled to people in wheelchairs or people with visible disabilities, something that's obvious to the naked eye. It includes, as you'll see, as we talk about in a few minutes, it includes intermittent types of disabilities, invisibilities that might be completely invisible to the naked eye. It also includes many mental disorders or psychological issues. It might not meet the definition of a disorder per se, but and we'll get to specifics in a minute so you'll understand what I mean. But appearances, it's not always obvious. It can be hidden, okay? And that is one point of tension. A lot of HOAs, the bad ones, might look at somebody and go, "You don't look disabled, so you're just faking. We're not gonna even enter into this interactive process that you're going to talk about later, because we don't see anything wrong with you." Well, that's just dumb. Okay, there are a lot of disabilities that are not necessarily visible.
Exactly.
Either because they are not visible at all times, they're intermittent, or because they just aren't the types of disabilities that scream disabled.
There are no physical manifestations of them. Yeah.
Maybe not, or maybe only in certain cases, right? For example, somebody that suffers from PTSD might not have a panic attack every second of the day. They might get triggered, but they have that diagnosis, and that is PTSD is one of those disabilities that we're going to talk about later. So, and again, another California aspect is that disabilities don't have to be permanent. They can be temporary. Sometimes you get a disability for a period of time, and then it's resolved. Sometimes they're permanent. Sometimes they're intermittent. They are dependent on some external factor, but those factors occur. You know, somebody that suffers from a seizure disorder, it could have it triggered by flashing lights, or it could just happen. But it doesn't happen all the time every day. So you might never know somebody has a seizure disorder, but that is certainly a recognized disability.
It is.
Okay. And so who is disabled? You know, it's the obvious ones. We'll include that in the definition. People in the wheelchairs, the people with the canes or the crutches, the people with the service animals. But there's a lot of things that aren't necessarily obvious. Okay. So anxiety disorders.
Yeah, that's a good example.
Okay.
Yeah.
If you have an anxiety disorder under a lot of conditions under California law, that would qualify. Okay. PTSD, we just talked about.
We did.
Cognitive impairments. If you are intellectually disabled or you are intellectually delayed and it affects daily life to a certain extent, you could be considered cognitively disabled and entitled to a reasonable accommodation that might help alleviate that.
A common one these days, autism. A lot of families deal with that.
Right. And there could be accommodations related to autism. We covered one of those when we were talking about some people that might.
Noise nuisances is one,
exactly.
one of those.
The noise nuisance,
right.
or there's somebody leaving their unit without proper clothing on, maybe.
Correct.
And maybe having some sort of, allowing them to put up signage somewhere to help them find their way back, or, or working something out with the neighbors to kind of walk them home, that kind of thing. We talked about that I don't remember the episode, but I know we talked about it.
It's been a while, but we did an episode on that.
I know we talked about it. I just don't remember in what context. There are a lot of other mental health conditions and you brought the autism. And so a disability is going to include all the things that homeowners are thinking of right now. The people that are listening to this or watching this podcast are thinking of, and then a bunch of other things they might not have thought of, like the ones we just talked about.
Right.
Okay. So I think disability is pretty easy to define once we've included the fact that it can include those temporary conditions, mental conditions, cognitive conditions, psychological impairments, that sort of thing.
Right.
Now, this is an area of contention that happens a lot, and that is, what is an HOA allowed to ask? You go to the HOA for an accommodation. I need a modification of this rule when it comes to me. That's really what it is.
Yeah.
In some way. They have a right to ask some questions to determine whether or not there's something here. Sam, what is one of the questions they're allowed to ask?
Well, they can generally ask about the nature of your disability that requires the requested accommodation and
are you disabled?
What the nexus is, what the connection is essentially to the accommodation you request.
So give me a very simple example.
Yeah. So let's just say you suffer from MS. Let's say, and you require adequate lighting because as part of your therapy, you need to spend time outside in your backyard or on your deck. And let's say you have special lighting that otherwise may perhaps constitute a light pollution, perhaps, or that's how HOAs may frame it as. I mean, this is an actual case I dealt with.
I've never actually, I don't recognize the facts of this case.
Yeah, so I mean, I don't think you and I have discussed it, but we resolved it successfully, and we used a request for accommodation, and we provided some limited information, not anything that would be...
No, but the lights were special lights.
They were special lights.
I didn't know that.
And this was on a railing on a deck where this individual suffering from the MS required as part of his therapy and safety, so that there wouldn't be any potential falls.
But the lighting part is the part I was interested in. Okay.
And so the short of it is the association worked with this individual.
Okay.
And essentially.
So in other words, the request there was, look, I have multiple sclerosis and I have some therapy lights that are important they are directly related to easing my condition or addressing my condition and making it easier for me to live my life. And unfortunately, those lights might run afoul of some of the rules that we have regarding lighting on decks or backyards, and so I need a modification. So the HOA was allowed to ask, okay, what's the disability? Well, I have MS. Okay, and what are you seeking? Well, I'm seeking these lights. Okay, so the nature of the accommodation and the nature of the disability. They can ask those two things, okay? That's it. You hit both of them. Okay, I'll give you another one, very common. Okay, we talked about this earlier in part one. You have some sort of mobility disability that affects your mobility. Let's say you could have MS or you could have something else, but something that limits your mobility, and your assigned parking spot is pretty far away, and you'd like one much closer. Or there's actually, maybe a portion of space near your unit that isn't designated as parking. You might say, I'd like you to designate that 10-foot space for me to park as my reserve parking. It could be either one. The HOA is allowed to ask, why do you need this? What's your disability? Well, I have X or Y. Okay, and the accommodation you're seeking is what? Well, I need to have a closer parking space. So I'd like you to grant me a closer one or designate this spot as a parking space, either one. Those two, they're allowed to figure out what you have and the nature of the accommodation, and even ask, how would this accommodation, ease the symptoms of your disability? That's kind of the same question, but you're allowed to ask that, and that's it. Sam, can they say, I want to see a doctor's letter? Yes or no?
No. The short is no.
They can't.
Yeah, no.
Can they say, I want to see your medical records?
No, absolutely not.
Can they say, show me in a medical record just the part where you're diagnosed?
No,
they can't.
No.
Can they say, I need to see something from your doctor that says that this accommodation is necessary for you?
They may not require it.
No, they can't. They have to and this is true, they got to take your word for it when it comes to accommodation. Like, for example, the lights thing. I've never heard of that before. Just because I haven't heard of it doesn't mean anything. If I'm on the board, I don't get to say, well, wait a minute, I need to go research that. Or, wait a minute, I want to hear from your doctor as to whether or not those lights are necessary to help ease your symptoms. They don't get to do that. They get to ask what the disability is and what the accommodation you're seeking is and how that's related. If you say, these lights that I want have been prescribed to me by my doctor or recommended by my doctor because they ease my pain, my migraines, or they ease this or whatever. I don't even know what they're used for, but they ease this or that. That's got to be good enough. The HOA board does not get to say, well, I've never heard of that. Therefore, I want to hear from your doctor and I want him to explain to us why those lights are helpful. Too bad. They don't get to ask. Okay. The bottom line is the HOA is entitled to bare minimum. They're entitled to the nature of the disability. Is this a disability? In order for them to evaluate, like if you were to say, well, I have a sprained ankle. I want my new parking space. No, that's not a disability. Okay. So they get to ask so they can evaluate, maybe through their lawyer or whatever, whether or not it counts as a disability. Yep. And they get to, in a rudimentary way, ensure that the accommodation in some way addresses a symptom of the disability. And that is as far as they can go. They don't get to ask for records. They don't get to ask for written documentation. They don't get to ask for proof. They don't get to have the doctor show up and testify on your behalf. They don't get to have a phone call with the doctor. Now, you might offer that. That's completely up to you. I don't, if it were me, I might say, look, if you guys want to talk to my doctor to fashion something that's, best for all of us, I'm okay with that. Here's his number, and I've given him permission to talk to you. You could do that, but you don't have to. And we're talking about have-tos today.
And they can ask about the viability of any alternatives.
Well, we're going to get to that.
We'll get to that. Yeah.
We're going to get to that.
Yeah.
As always, Sam likes to jump ahead. We'll get to that later when we talk about the interactive process, which is required under the law.
Yeah.
And so let's leave it at that for now. But bottom line, reasonableness is key. Everything turns on reasonableness. That's a magic word here. In this entire process, if the parties are being reasonable, things will work out within confines of the law. That's how it works.
Yeah.
It's manifestly unreasonable to say, give me proof of this or proof of that.
Right.
So you're not using reasonableness. But when it comes to these accommodations, so once a homeowner qualifies, you have a disability that constitutes a disability under the law. Okay? The legal question is no longer whether the HOA has to act. The legal question is how will the HOA act, or how must the HOA act?
Right.
Not whether they'll act. Once you've got the disability and you've brought this to their attention, obviously you brought it to their attention because you're seeking an accommodation. At that point, it's not whether they're going to act, it's how are they going to act.
Correct.
Okay? And the question becomes, how far is the HOA required to go? Or, stated differently, where is that reasonableness line drawn? Okay? You were alluding to that, and we're going to get to this later, so I'm only going to make a very quick comment. You were alluding to that when you said this interactive process, because an HOA is not necessarily going to be required to, there might be multiple different kinds of accommodations that will accomplish the same thing, and the HOA could choose among those if there's a difference, it's a qualitative difference in effect of the HOA.
Right.
If they're equal over here, the HOA might have a choice over here.
And just to add to that, not unilaterally choose or probe into which one they prefer, but work with you as part of that process.
It isn't about that. It isn't about reasonableness focuses on whether, okay, let me back up. It isn't about what's best for the HOA, what's easiest for the HOA, what in some cases might be cheapest, although for the money thing, it's usually the homeowner that's paying. But it's not about that. It's more about the reasonableness of, is this accommodation necessary for access or mobility, okay? Or whether it imposes an undue burden, and that's the part of the interactive process we'll get to later, or whether it fundamentally alters either the nature of the housing or the HOA's operations. Now, in most cases, the answer is no, it doesn't. Building a ramp where one didn't exist before, or crafting a new parking spot that never existed before, those don't cause permanent changes to operational modalities of an HOA. They just don't. But the law recognizes the possibility of that being a consideration, and so it allows for that. That's all that means, okay? Now, let's talk about the most common types of accommodations. And we're going to spend a little time on this because this podcast, above all else, is educational. And so I want to give examples because people learn best with examples, real world examples. What are the types of accommodations? You gave me one I'd never heard before. I have never heard of special lights. It makes total sense, and it seems obvious to me now that I've heard it, but I never would have come up with that.
An actual case,
Yeah, and I don't remember the facts of that case. Must have been, I don't know. I just wasn't aware of it. So the most common types of accommodations that we see include things that either, well, we talked about this ad nauseum. We'll mention it one more time. Building a ramp. Okay? Building a ramp where none exists. Obviously, the ramp's going to be for somebody that's in some sort of wheelchair or device that rolls because that's when you need the ramp. Okay? Handrails. Same vein, right? Handrails for people that have balance or mobility issues. Okay? And by the way, age can be considered a disability under FEHA if it's related to a condition that comes from that age. For example, you're 99 years old, you might need the handrail because you cannot safely walk without a walker or the handrail. You might not be able to navigate at all. That would count as a disability, even though in their traditional definition, it might not be. Like, that wasn't done to you, it just is. You just survived long enough, and now it is. Okay? Allowing, so you have, on the one hand, allowing construction of some sort on your property or the common area. Another one is to allow deviations from normal standards, right? Door hardware, thresholds, flooring material. If you have a balance issue, and you're or you have that condition from that Bruce Willis and Samuel L. Jackson movie, that set of 3 movies where his bones are like glass and they break. You do one little fall and all of a sudden you break. You might want a different surface. You might say, look, the cement in front of my place is too slippery. I'd like to add a more rough cement. Something that I can purchase on. I could see that. I haven't had a case like that before, but I've heard of cases like that. Okay? Whenever any kind of exterior fixture modification, whenever basically compliance creates a functional barrier, you want an exception to that compliance, okay? So let's get to specifics. The right to have a vehicle that might otherwise be restricted. A lot of HOAs, mine included, do not allow Sprinter vans. They actually call that by name. They say, that's an example, but it's an example that's called out by name. So vans of a certain height or length are not allowed, and Sprinter vans violate both. So you have an HOA that has a rule that's completely enforceable that says no Sprinter vans. However, because of the nature of let's say you're in a wheelchair, and your modified vehicle is a Sprinter van. Because it's a van that's big enough to hold not only passengers that you might carry, but also your wheelchair and all the accessories and the elevator thing that lifts you up into the van. And you need that size van to be able to drive, to be able to move.
Absolutely.
That HOA, I can almost guarantee you, not almost, I'm going to tell you, that HOA is going to have to allow the Sprinter van. Now, other people could say, wait a minute, that's not fair. I want a Sprinter van. I want to be able to have one because they're really neat and I want to be able to, well, too bad. Okay? That's the way it is. You don't require the accommodation because you don't have the disability that would require that accommodation. This person does.
And that HOA, that board is not running afoul of enforcing governing documents.
And nor is it selective enforcement.
They're complying with operative law.
They're complying with federal and state law in that case. And more importantly, they're acting reasonably. A person that I can have a sports car if I want one because I can get in and out of a teeny little sports car. A person with a wheelchair, for example, can't have a wheelchair elevator thing attached to a Porsche. I've never seen one that would work on a Lamborghini. Whatever it is. Point is, they need the van because that's what holds their equipment. Then they have a right to that van. Even if the HOA, rightfully so, has a rule that says no Sprinter vans. Too bad. If this person has a Sprinter van, this person's going to keep that Sprinter van. Okay? Or, same vein, that same Sprinter van in a community where you must park your vehicles in your garage, Sprinter van might not fit in the garage. Exception, they can park on the street, they can park on the driveway, they can park in guest parking. Whatever the situation in your complex is, they're not going to be required to be in that garage if the van won't fit. Well, they have to get another kind of vehicle. No, it's not how it works.
Or if they have some time limitation, something arbitrary as far as loading, unloading at certain locations, and they need longer to get in and out of those vehicles, accommodating them for those purposes.
And by the way, we all know this. People that have the handicap placards, they can park in places that other people can't park in. And they don't have to pay
the meters.
Meters.
Yeah.
Okay. That's because that's an accommodation that's built into the law. It's the same sort of thing here, guys.
Right. Yeah.
Okay. The right to install handrails in common area,
Yeah.
or the right to to get permission to build a ramp in a common area leading up to your unit. If there's steps there and they don't have a way for you to roll up, and you don't have one of those cool wheelchairs that actually knows how to climb stairs, and I've seen those are kind of neat.
Right.
But you have a right to make that ramp, build those handrails, or put that little driveway thing in the sidewalk if that's what you need for mobility, and that would be the accommodation you're seeking. We see that. We've seen that dozens of times. Remote controls, key fobs, gate codes, automatic door openers, or exceptions to locked entry rules. There might be a situation where you're limited to the number of fobs you can have. You can have extra fobs, right?
Yeah.
If you need to allow your caretaker and you, whatever. Right. Or we talked earlier, I think in part 1, we talked about some things that are time coded or time limited. Certain areas of ingress or egress might be limited on time because they don't have a doorman or a gate guard or whatever there. It would be an exception for somebody that needs it because it's much closer to their unit. That sort of thing. Okay. Obviously, use of assistance animal of some sort.
That's
okay,
big.
that's going to be covered.
Right.
And by the way, use of assistance animal, they are not pets under the law, meaning if your assistant, if you're seeing eye dog, for example, let's say you've got vision impairment and you've got a seeing eye dog, and it happens to be, now this isn't the case most of the time, but it happens to be a pit bull. I'm only using that because that's a breed that many HOAs have
specifically
said you can't have a pit bull. Okay, doesn't apply. Breed restrictions do not apply to service animals. Weight restrictions and size restrictions do not apply to service animals. Number of pets restrictions does not apply to service animals. So if you already let's say your HOA allows 2 pets and you have 2 dogs, and you have a third dog that is a service animal, that doesn't count as a third dog. You have 2 dogs and you have a assistive device, because if you listen to our podcast on service animals or read the articles, when it comes to service animals, not emotional support animals, but service animals, they are defined as assistive devices, like a wheelchair or a cane.
Like a medical instrument.
They are medical devices, is what they are. Okay. So service animals, right? Allowing a non-standard path or gate or entrance. Okay. When a designated route might not be as efficient for you or might cause some sort of difficulty. Right. Give me another one.
Let's say accommodating participation let's say remote participation because you're unable to be on site or in person for something.
Yeah. What you mean by that is, and remember, right now, especially after COVID, Zoom has gotten sophisticated. We got all these variations where you can do remote stuff. But years ago, that was really much harder to pull off.
Correct.
When you talk about remote, you're not talking about a remote control. You're talking about, give me an example of somebody that might need to go to a disciplinary remotely. And the HOA would have to allow it, not just choose to, but have to. Give me an example.
Let's say a certain community does these in person, let's say at the clubhouse for those types of meetings. And in this case, if you need that special accommodation, they would have to provide you a virtual meeting via Zoom or WebEx or whatever they use.
Right. I'll give you an example. I had a client many years ago, this was before your time at my firm. This is about 20 years ago. Okay. So about 20 years ago, I had a client who had a severe case of agoraphobia.
Oh.
Okay. Agoraphobia is the fear of leaving your house, a fear of being out in public or being in crowds. Okay. This person's agoraphobia was so bad that he could never leave his house.
Wow.
He worked from home, and this was 20 years ago. So this is well before, we had the video meetings and all that stuff. I mean, that really didn't exist.
Yeah.
But he had to make it work. He actually had a good job. He was a web designer and IT guy, but it was all remote, right? He could not leave his house. If he had to go to court on a traffic ticket, he was allowed to appear in court through the phone. And this was well before we had, the systems that we have in place today in courtrooms, where we appear in court via Zoom all the time. Not Zoom, but the same type of, it works like Zoom, right? We appear in court all the time. It saves our clients a lot of money, and we do it when we can. He's allowed to do it for anything, okay? His doctors would come to the house. He could not leave his house. I tried. I got to know him very well over the course of this case. And it wasn't an HOA case, by the way. It was a different kind of case. It was a business dispute case. But I did try, and he was incapable. For whatever reason, could not cross the threshold of his home. Okay? He would have to be allowed. Not at the whims of the HOA, but have to be allowed to attend board meetings, open board meetings, or hearings, or anything else remotely.
Yeah.
That's an accommodation, and no other accommodation would be able to resolve that.
Right.
Because unless you wanted to have the meeting at his house, he was okay with that, I guess. He could have people over. I was there. I mean, he could have people over. So I guess if they agreed to hold the meeting there and have everybody in his backyard, I guess that would have worked. He could attend in person. But other than that, he was incapable. So that's a good example of
Another one real quick, we referred to this earlier in cases such as, let's say, we mentioned autism as an example, where you have noise nuisance elements. So what otherwise would be treated as a noise nuisance, let's say at odd hours, or let's say you leave your house in a condition that would otherwise be something that they would cite as part of their rules and guidelines. Tourette's. And so in those cases, they have to take that into account and make the
There's a great movie. There's a great movie back from the 90s with Richard Dreyfuss and
what about Bob?
Bill Murray, called What About Bob?
Yeah.
For those of you who have seen it, you'll remember this scene. For those of you who haven't seen it, I recommend seeing it. It's one of the, it holds today. It's still one of the funniest movies. I remember at the time I actually was rolling in the aisles. I was laughing so hard. It is still to this day one of my favorite top 7 comedies of all time. I recommend it for anybody that hasn't seen it. What About Bob with Bill Murray and Richard Dreyfuss. Anyway, there's a scene in there where Bill Murray's character, who has a variety of different phobias and psychological limitations, is hanging out at his psychiatrist's summer home on Lake Winnipesaukee, New Hampshire, and he's sleeping over. I won't get into that why he ends up there, but with his doctor's 12-year-old son, and they're talking about this thing, and the kid's like, "Well, why don't you just call it Tourette's? Yeah, you have Tourette's." And then they start shouting obscenities. It was very funny. If you have Tourette's and you have the type of Tourette's that it maybe manifests with inappropriate utterances of obscenities as opposed to, let's say, tics, right? Because Tourette's manifests in multiple different ways. But let's say you have the type where you would suddenly scream things you shouldn't be screaming. You would be excused from the normal nuisance.
Yeah. Because
you have to be able to exist and live.
Right.
Okay, the accommodation, society doesn't get to say, well, no, you have to stay in your house all the time and never leave. Because God forbid one of us is offended by what you say. Oh, it's too bad. You got to live with it. Okay?
Yeah.
That's the type of accommodation the HOA would have to, you're not going to be subject to the same nuisance standards that somebody else might. Now, if there are things you can do to tampen that down, you're obligated to take them. Again, what's that magic word? The reasonableness word.
Correct.
Both sides. Applies to both sides.
Indeed.
Okay. Yeah. So anyway, that's where you were going, I think. And yeah.
Exactly it. Yeah.
Exactly. Now, let's talk about this interactive process. You brought this up a while ago. I'm going to let you take off from here. Talk to me about what is this interactive process and what does it require from the HOA?
So when a homeowner submits an application for a request for accommodation, the HOA may engage in what's called this interactive process by gauging the reasonableness of that request. So we talked about some portions of that earlier, which was starting at the outset in terms of what's the nature of your disability that you're claiming, what is the, concession or accommodation you're seeking, what's the connection or connectivity between those two, and then how can we get into gauging and analyzing as an analysis essentially of the viability of that and any alternatives that may exist that perhaps may be more reasonable.
So the viability of the accommodation you're seeking versus whether or not there might be another type of accommodation that accomplishes exactly the same thing, gives you the same mobility, same access, whatever it is, but might be easier or less intrusive to neighbors or something like that.
Correct.
A lot of the time, the accommodation is the only accommodation. For example, the parking one. I can't imagine a scenario where if you need closer parking, there's going to be another accommodation that accomplishes the purpose of that accommodation, which was...
You're not going to teleport or fly them over. So,
There is no other means. Right. If there was if there happened to be a moving people mover, they could say, use the people mover, or we'll build a people mover for you. That might be fun. Let's try. Totally fictional. Let's say your request for the accommodation was, I need you to build me one of those straight escalator things, those things like at the airport where you stand and it just makes you go. I want you to build me one of those so I can get, because I'm 100 yards away, I want to get to my house. They might say, well, that's really expensive, and we don't think, and then you're going to end up having to take a lot of our common area, and even though you're paying for it, it'll take away our sidewalk. So how about instead of that, we just give you a parking spot right in front of your house?
Right.
There's an extreme, ridiculous example to make the same argument that we're saying is. So part of this interactive process basically is, here's the requirement. In very simple English. When you bring to the board's attention the nature of the disability and the request for the accommodation, the HOA has to, at that point, must engage with you in good faith in this process to figure out how to get you what you are entitled to, how to get you what you want. Is there an easier way that is equal? It cannot be, yes, there's a easier, quote, way to do this, but it also only gives you 60% or 70% of the mobility or access that your accommodation would otherwise give you. No, at that point, you get yours, okay? But they have to consider the specific needs of the homeowner. They do not consider what's easiest for them or what the rules say, because that's not relevant at this point, okay? The HOA has to explore reasonable alternatives if there are any out there, reasonable alternatives.
Correct.
Okay? Now, bad HOAs are the ones who do stuff like this, right? They fall back on reflexive denials. Nope. Stop where you are. Can't do it. Or I've been on the board 15 years and we've never had to do that before, so we're not going to start now. Well, I don't care if you've never had to do it. You've never had somebody with MS in your HOA. Now you do.
Right.
Welcome to the real world. Okay? We don't allow that. Or, that's never been allowed. No, that's against the rules. That's irrelevant.
Right.
Too bad. Okay? We've seen this. Bad HOA board members who decide suddenly they are trained neurologists or trained medical doctors and they substitute their own judgment or medical diagnoses. I don't think you're as disabled as you are letting on. Well, I don't care what you think.
Or I type your symptoms into Google and AI, and then they
I put your symptom into ChatGPT, and it said you can walk 100 yards, and it was good for you. Okay? Here's one we see bad HOAs do. They treat you like they're doing you a favor. You should be thankful that we're working this out with you, because let's say there's some dispute during this process, and you've seen them, and they take the position that, you're ungrateful. Well, wait a minute. You're not doing this as a favor. The law requires you to do this. I'm not ungrateful. I'm telling you what you're going to do. Okay? So a bad HOA board member, the wrong temperament type, is the person that treats this and the person that's disabled as if they're doing them a favor. They're not. Okay? Or they use procedural hurdles to avoid substantive decisions. They keep tabling it.
That's a common one, yeah.
Or how about the endless documentation demand train that some of them get on? They put so many impediments, or they move the goalposts, that it seems like I'm never going to get what I'm supposed to get. Meanwhile, you're suffering, whether because of mobility or otherwise. There is a access or mobility issue that's not being addressed to your own property because of this, and they're taking their time removing the goalposts. Yeah, you don't have to tolerate that. Or how about this? They offer a compromise that does nothing to address the access issue. So you're seeking easier access with a closer parking, and they offer a covered, a reserved parking port for you instead of the open space. I don't need the cover. What is that? How's that going to solve the fact that I'm in agony walking all the way to my unit? Offer me a garage 100 yards away, a separate garage or a covered port isn't a compromise. It doesn't solve my problem. The access, the accommodation has to solve the problem or reduce the effects of the problem.
Correct.
Right?
Yeah.
Now, once homeowners can recognize or understand that their issue about their disability or the accommodation they're seeking is being mishandled, they're in a much better position to escalate this legally and not escalate it emotionally. When you know what your rights are, you know what you're going to be able to do, and that really helps a lot with the anxiety and the worry that comes with this, because you're going to meet a lot of bad HOA members and a lot of bad HOA board members. They exist. And if you're lucky enough to live in a good HOA, great. But if you're not, it's not a reason to be depressed or sad. You understand what your rights are after listening to this podcast, and then you're going to understand, okay, I'm going to get this. It's just going to take a little longer, but I'm going to make them pay. Okay? So let's talk about, because ultimately my goal, and I talk about this in my book, HOA HELL, which is now available for distribution, and thankfully, knock on wood, it's a #1 bestseller on Amazon for real estate books.
Congrats.
But let's say, and I talk about this in chapter 12, we talk about, it's where I wrap everything up in the book, all the stuff that you were taught from chapters 4 through 11, this is the wrap up on how to put it all together. And I call it stacking rights or creating leverage. Okay. The goal here is to create leverage. It's to quickly and cleanly create leverage while avoiding mistakes that weaken your claim. So here are some steps that if you find yourself in a situation where you're seeking a valid accommodation and your HOA board is doing one of the many things that we've talked about to stand in your way, here are things that you can do on your own before it's necessary to call us at MBK Chapman. When we get involved, we're the big guns. When we get involved, we'll set your HOA straight. But there are a lot of things you can do before it gets to that. Let's talk about those. Okay? What's the first one is put it in what?
Put it in writing.
Put it in writing, guys.
Always a good idea.
If something happens verbally, it didn't happen at all. It's a mantra at my law firm. I've been teaching my lawyers that have worked for me for 15 years. If it didn't happen in writing, it didn't happen at all. Yeah. If you had a conversation with opposing counsel or with your client or with the other side, nothing that happened in that conversation is ever going to be evidence.
And with the HOAs, it's especially because you have multiple parties. You have the property manager. You may have multiple representatives.
Multiple board members.
Multiple board members.
Exactly.
So you don't want a he said, she said scenario.
Verbal conversations or verbal communications disappear forever.
They do.
The second they're out, they're gone. They float away. Okay. Writing lasts and it forces accountability. Okay. Another one is frame the issue as access, not what's fair or not fair.
Right.
People can have different ideas or definitions about what's fair. It's very hard to have a differing opinion as to what provides access or doesn't.
Correct.
Or what is easier access or not.
Right.
Okay? So you want to frame it in a non-emotional way. This is about me being able to access my property or me being able to function at my property in a way that everybody else can.
And that's oftentimes difficult to do, especially for these types of applicants, because you're in pain and agony and you're frustrated with the moving goalposts and obstructionism. But be dispassionate if you can and frame it in a logistical sense. Yeah.
And focus on the functional barrier that's created by the disability.
Right.
Okay? Don't function on the pain and anger or whatever that stems from that functional disability or the functional lack of access. Focus on, I have this situation that's limiting my access. This accommodation is going to relieve that. I need to get it, and you're standing in the way of getting that, so I need to make that change. Okay? I need to get you to understand that I need this accommodation. So you focus on the access issues and the functional nature of it, not on the emotion. Okay? Be specific about what you need. This is a time when being vague will absolutely result in delays, result in misunderstanding. They won't understand. You're not communicating the nature of your needs, and they need to at least understand what those are in order to be able to grant your accommodation. So specific requests require specific responses. Vague requests, you get vague responses. You get in what you put out. So be specific when it comes to this. I have MS, and these lights that I'm seeking to put up, which would otherwise be prohibited, are necessary part of my treatment because they help alleviate this symptom or whatever. That's pretty specific. Okay, I need you to allow me to have some lights put up because I have a disability that is affected by, or that I don't get any relief from other than these lights. But you don't talk about the nature of the lights, how many lights, where you want to put them.
Right.
Be specific. Okay. If you choose to, and you have a right to, limit the medical data you're sharing. It's nobody's business but your own, and certainly not the board's business or the manager's business or the lawyer's business. What your treatment plans are in specific, or what medications you're on, or how long you've suffered from this, it's none of their business. Now, if you want to share it, share it. It's your information. Do whatever you want with it. It's yours. But you don't have to. So if you want to protect that because you feel for yourself it should be kept private, then limit the detail you give. Okay? And Sam's very favorite one, document.
Yeah.
Okay? If you're going to be at a meeting and you want to record it, ask for permission to record. If they say no, then you can't.
Right.
Then what you would do, if in the absence of permission to record, you would, right after a certain meeting, send a confirming email saying, hey, thanks for meeting with me. This confirms what we talked about. I told you this. I requested this. You said no. Or I did this. You said this. And you said you wanted more information. I'm going to get that to you. Or whatever it is. Be specific, but document. Okay? Now, if those things, you've tried all that, it's not working. Here's where you come to us at MBK Chapman. This is where you say, all right, time for the big guns. I'm calling in the experts. Okay? I'm calling in the Marines. Okay? That's when you call us. And HOA outright denies your request for an accommodation. You have a valid disability under the laws that we talked about. Your request is among the reasonable requests that we talked about. We gave tons of examples, and they just said, nah, either because we've never done it before, we've never had anybody ask, or we think that's going to invite other people to come after us for selective enforcement. That's wrong. But any of those things, they outright deny you, you come to us. Dealing with it yourself is going to be hard. Once they've made a decision in bald-faced violation of very well-known California and federal law, come to us. Okay? The HOA keeps delaying or demanding unnecessary information. So they were open to everything. They entered into this interactive process with you, but then it's a month later and they still haven't gotten anywhere. Come to us. Okay? They try to reframe the issue as rule violation as opposed to fixing an access issue. Okay? You come to us at that point. Or they retaliate or selectively enforce against you once the nature of your disability comes to light, and they not only do they say no, but they punish you for even bringing it up. So now now that we know that you routinely park in guest parking because we're going to start looking out for your car, and we're going to start ticketing you, and then we'll call you into a hearing. That's what I mean by that retaliation. Maybe in the course of explaining, saying, hey, I've had to park in guest parking because my space is too far, and let's say homeowners aren't allowed to be in guest parking. We have a case right now where that is the sole issue in the case. And our client, this was important to this client. Client has spent tens of thousands of dollars, and we ended up settling at trial, and we got everything we wanted. Okay? Bottom line, some HOAs have that rule. Okay, well, now that you've told us that you are parking guest parking, we're going to start looking for your car and ticket you. No, you come to us. Or the homeowner feels pressure to either give up or weaken what they're entitled to because they're being either implicitly or explicitly threatened with being ostracized in the community or to being retaliated against. That sort of thing. Anything else from your end on that?
No, I think that's pretty good. I think we covered quite a bit, and it's not just theoretical or academic. These scenarios happen all the time, and it's heartbreaking in some instances because you see how people are defeated, fatigued, they run out of steam.
How many cases, if you had to guess at the firm right now, do you think touch on, if not directly, indirectly on any of the disability-related issues we talked about? Just active right now.
My sense would be probably more than a dozen.
I can think of 4 right off the top of my head, and I don't handle day-to-day cases, folks. I'm the managing partner at the firm. He's in the trenches every day.
I have several myself, and I know that Sarah and other colleagues have.
So I could think of 4 off the top of my head that I happen to know the facts to, including the one I just referenced. This is a real thing, and it happens all the time. It shouldn't, but it does.
It does.
Okay. All right. So disability accommodations and disputes related to disability accommodations are, as we just said, unfortunately a frequent occurrence in California HOA life. And it shouldn't be. But you have some powerful laws. If you're disabled, you have powerful laws, both on the federal and the state side, that are designed to maximize your chances of getting accommodations that will, where possible, minimize your access difficulties or pain or whatever it happens to be in your case. And you're entitled to these accommodations under the law. And there's a mechanism built into the law, and your HOA is bound by that law. And to the extent your HOA is one of those bad HOAs, is not cooperating or is not engaging in good faith or acting reasonably, which is the magic word of our 2-part series on this, that's when you come to us at MBK Chapman, because I guarantee you we'll set your HOA straight. If you like this episode, please hit the like button. If you haven't already done so, please hit the subscribe button. If you want to leave a comment, ask a question, please do so. We do look at those. Until next time, folks, have a wonderful day.